For the first execution of the year, Demetrius Frazier will die by nitrogen hypoxia February 6th. Frazier was convicted of robbing, assaulting, and murdering Pauline Brown back in 1991.
Get your ass lighter, man. DC, the boys, Alabama Prison Profiles. What's going on with y'all, man? Make sure y'all like, subscribe, share the video, comment on the video, donate to the channel's Cash App and PayPal if you're feeling generous, man. Want to give a shout out to our sponsor, PAX Los Angeles. Make sure y'all visit their online store linked in the description for the gas, edibles, vapes, merch, etc., man. Supposed to get mine this week, man. Niggas from FedEx and I stole my shit, man. Got that shit on the neighbor's ring camera, man. That shit crazy, man. Insane, bro. Send me another pack coming, man. Shout out to Ann. You know what's going on. Now, y'all wanted to know what games I'm playing on the new console, man. I'm bouncing back and forth between Mafia 3, Doom Eternal, SnowRunner, and me and the BM have been replaying the Gears of War trilogy, man. She's hooked. Done got me the console, but now I gotta fight her to play it, man. I guess there's worse problems to have. Now today, we're gonna be looking into the crimes of the state's first scheduled hat of 2025, beginning next month. Let's hop right into that right now. Governor Co.AgMusic has set the execution date for Demetrius Terrence Frazier, who was convicted of capital unaliving for the 1991 Jefferson County unaliving of Pauline Brown. The execution by nitrogen gas hypoxia is set to occur in the 30-hour window from 12 a.m. February 6th to 6 a.m. February 7th. A jury convicted Frazier, now 52, of capital murder, rape, and robbery of Pauline Brown in her Birmingham apartment, court records show. If the execution goes forward, it will occur in the death chamber at the William C. Holman Correctional Facility. The facts of Mr. Frazier's Michigan murder case are as follows. In Michigan, on July 9, 1992, Frazier was charged with first-degree unaliving for the fatal shooting of Crystal Kendrick. He was also charged with raping 8 other women. Prior to his trial for unaliving Kendrick, Frazier and his lawyers attempted to have his confession to Kendrick's unaliving ruled inadmissible. Frazier submitted that he fell in love with Detroit homicide detective Monica Childs, who is in charge of the case, and he was thus tricked into confessing to both murders of Kendrick and Pauline Brown. According to Frazier's counsel, Childs allegedly offered Frazier a promise that he would not be sent back to Alabama to stand trial for Brown's unaliving, given that Michigan did not have the death penalty, while Alabama still allowed the death penalty for homicide offenses. However, the confession was ultimately ruled admissible in court after the court records rejected Frazier's allegations. Frazier also reportedly punched the prosecutor in court during his pretrial hearing. On April 8, 1993, a Michigan trial court found Frazier guilty of felony murder and felony firearms possession in the case of Crystal Kendrick's death. Frazier was sentenced to double terms of life imprisonment for both counts in the state of Michigan. In addition to the charges he faced for Kendrick's death, Frazier was also tried in Michigan for other rape and robbery cases he committed prior to the murder of Kendrick, mainly 1 case of armed robbery and 2 cases of rape committed on September 1st, 1991. Frazier was handed another 2 life sentences, plus 60 to 90 years jail time for these cases on October 20th, 1993. The facts of Mr. Frazier's Alabama case are as follows. In 1992, while in custody of the Detroit Police Department for the unaliving of Crystal Kendrick, Frazier was interrogated by Detective Kenneth Bresnan. During this interrogation, Frazier confessed to the murder of a woman at Fountain Heights Apartments in Birmingham, Alabama. Detective Bresnan contacted the Birmingham Police Department. Detective Kenneth Glass of the Birmingham Police Department traveled to Detroit to further interrogate Frazier. Frazier gave Detective Glass a statement which was recorded on audio tape. In that statement, Frazier again confessed to the murder. His statement related the following facts. Early on the morning of November 26, 1991, Frazier saw a light on in Pauline Brown's ground floor apartment at the Fountain Heights apartment complex in Birmingham. He removed the screen and entered the apartment through a window. Frazier searched the apartment and found $5 or $10 in one of the bedrooms. Frazier then heard a TV on in one of the other bedrooms and went to that bedroom to see if anyone was there. He found Miss Brown asleep in the bedroom. He awakened her. Armed with a .22 caliber pistol, he demanded more money. Miss Brown gave him $80 more from her purse. Frazier then forced her at gunpoint to have intercourse with him. During this heinous act, Miss Brown begged Frazier not to unalive her. When Miss Brown refused to stop begging for her life, Frazier put the pistol to the back of her head and fired the gun. Fearing that someone had heard the gunshot, Frazier left the apartment. He went across the street to wait for police to see if anyone had heard the gunshot. Satisfied no one had heard the shot, he returned to the apartment. He searched the apartment for more money and confirmed that Miss Brown was dead. He then went to the kitchen, ate 2 bananas, and left the apartment. He threw the pistol in a ditch. A Jefferson County grand jury indicted Frazier on 3 counts of capital unaliving. Count 1 charged Frazier with the offense of unaliving made capital because it occurred during a robbery. Count 2 charged the same thing, made capital unaliving, because it occurred during a burglary. Count 3 charged Frazier with the offense of unaliving made capital because it occurred during a grape. Frazier, who had been 19 years old at the time of the crime, applied for youthful offender status. Following a hearing, the trial court denied his application. At his arraignment, Frazier pleaded not guilty to the charges in the indictment. Defense counsel filed several pretrial motions, including a motion to suppress Frazier's statements and a motion for a court-ordered mental examination. The court denied both those motions. Damn, what's wrong with the mental evaluation, court? As to count 1 of the indictment, the jury found Frazier guilty as to count 3 of the indictment, found him guilty of the lesser included offense of intentional murder. The jury was unable to reach a verdict on count 2 of the indictment, and the court declared a mistrial as to that count. The jury recommended, and the trial court imposed, a sentence of death. As to his conviction for the lesser included offense of intentional murder under count 3 of the indictment, the trial court sentenced him to life imprisonment. The Court of Appeals affirmed Frazier's conviction and sentence of death as to count 1. In his petition for an appeal, Frazier raised several issues concerning the merits of his conviction and his sentence, all of which he raised on appeal at the Alabama Court of Criminal Appeals. Frazier would argue the trial court committed error by failing to instruct the jury to ignore an outburst in which Frazier threw an object at the jury and accused the jury of being racist. During the prosecutor's opening statement, Frazier threw a writing pen in the direction of the prosecutor and the jury. The pen narrowly missed one of the jurors. Frazier then yelled the following: "Shut the fuck up. That jury right there is racist, man. Man, that jury is racist, man. Look at him. That guy looking at me, man. Man, that jury is racist. That jury is racist, man. Look at him. Look at that jury, man. 10 motherfucking white jurors up there. Fuck that." Unquote. Frazier was escorted out of the courtroom, and the court instructed the prosecutor to continue. Before the prosecutor resumed his opening statement, Frazier's counsel moved for a mistrial, arguing that the jury would not be able to render an impartial verdict because of Frazier's inflammatory remark. The trial court denied that motion. The court then discussed with attorneys whether the trial could proceed in Frazier's absence. Ultimately, the court decided to move the trial to a different courtroom so that Frazier could observe the trial from a media room. Frazier also argued the trial court committed reversible error by failing to instruct the jury to disregard his outburst. In reviewing this issue, the Court of Criminal Appeals stated although perhaps the better practice would have been to question the jurors immediately regarding any prejudice that may have occurred as a result of the defendant's outburst, and then to instruct the jurors to disregard the disruptive behavior under the unique facts of this case, we cannot say that failure to do so amounted to plain error. The court will go on to elaborate. One cannot purposely create grounds for a mistrial by deliberately causing a disturbance during the trial. Otherwise, a defendant faced with imminent conviction could disrupt the trial, prejudice himself in the jury's eyes, and therefore be entitled to another trial. The trial court concluded Frazier's outburst was purposeful and accordingly denied relief except for polling the jury. The court found the failure to declare a mistrial or to instruct the jury to ignore Frazier's outburst was not error. Attorneys for Frazier have an ongoing federal lawsuit seeking to block the state from carrying out his execution unless the state makes changes to the protocol. His lawyers argued the nitrogen gas causes conscious suffocation, and that earlier nitrogen executions did not result in swift unconsciousness and death. Frazier is currently awaiting execution next month at William C. Holman Correctional Facility on death row. And there y'all have it, man. Let me know what y'all think about this in the comment section, man. First of all, I want to say condolences, right, to the victims, Miss Kendrick and Miss Brown, and both of their families, man. Dude sounds unhinged AF, man. A serial, what's the name, man? That's two hats on him. Come on, man. Hard to argue against this one, man. Then you done slapped the shit out the damn attorney in there, man. Done threw an ink pen at the white folks. Like, granted, bro was right. More than likely, but still, don't affirm these folks as, you know what I'm saying, already convictions about. But anyway, man, that's what sounds like a menace to me, though. Hell, maybe he's reformed his behavior since his incarceration. Who knows, man? But hey, the nature and the seriousness of the offense. I'll keep y'all updated on this case and revisit it around again the next month when Mr. Frazier is set to die by the hands of the state using the new execution method of nitrogen hypoxia. Let me know what y'all think about this in the comment section, man. Like, sub, share, donate to the Cash App and PayPal if you feeling real. Mess with our sponsor in the description. DC the Boys, Alabama Prisoner Profiles, out the gate.